Straight ahead on Law and Crime Daily, a hearing over whether to remove the prosecutor of the so-called doomsday cult couple. What was said to Lori Vallow's sister on a secret recording about Chad Daybell.
And he uses this kind of, I call it spiritual abuse, spiritual manipulation. Yeah.
No charges will be filed against police officers in the shooting of a man left paralyzed. Our experts break down the Kenosha District Attorney's decision in the Jacob Blake case.
So it is our decision that no charge will be filed.
Plus, a judge sentences a mother to 5 years in prison for the death of her daughter. A look back at the Pajama Pants strangulation trial. Law and Crime Daily covering court cases from coast to coast. Welcome everyone to Law and Crime Daily. I'm Brian Buckmire along with Terri Austin. Defense attorneys for the so-called doomsday cult couple are trying to get the prosecutor removed from the case. Lori Vallow and her husband, Chad Daybell, are charged with concealing, altering, and destroying evidence in connection with the deaths of Vallow's 2 children. The bodies of 7-year-old J.J. Vallow and 16-year-old Tylee Ryan were found buried in a shallow grave in Daybell's Idaho property. The couple was arrested last year in Hawaii, but neither are facing charges for murder. Now, their defense claims the prosecutor tried to intimidate Vallow's sister and sister-in-law during a meeting in Arizona. An attorney for the 2 women secretly recorded the meeting, and we're hearing it for the first time during a court hearing in this case.
Our goal is to have such a strong case that when she has competent counsel, I don't know if you know this, her attorney's never handled a felony before. He has never done any meaningful criminal work at all, and he doesn't know what he's doing. He's a nice guy.
Yeah.
Otherwise, he's lying about me, but he doesn't know what he's doing. And once we file further charges, she will be appointed counsel who will know what they're doing. And our goal is to put together such a case that they're smart enough to say, it's going to be better to talk.
Mm-hmm. So I'm so torn with all of it. It's such a conflicting feeling to know that this person's been good her whole life and then has made this error in judgment and got sucked into this vortex of this man.
Mm-hmm.
And I feel for her. I just have so much compassion towards her because I know that's not what she would have ever done on her own.
Right.
And so she has to pay the price for this forever. And I hate that for her. So I'm very conflicted. But I was going to ask you on the concealment, or not the concealment, but on the conspiracy to commit murder, what's the weight of that in terms of jail time? Is that a death penalty thing, or
it is a death penalty case now?
Are you planning to ask for that for them, or do you not?
We sure hope we don't.
Okay.
A lot of that will depend on her.
The defense called the attorney for the 2 women to testify. He was at the meeting with the prosecutor, Rob Wood, and Summer Shiflett, and is the one who recorded it.
A flag went off in my mind when he brought his deputy in to meet my client and myself, and to kind of do this introduction stuff. And that's when I got my recorder out and turned it on. That put a flag off in my mind that this wasn't going to be, hey, I'm John, or I'm Rob. This is my deputy. Good luck today. Thanks for doing this, and we'll talk to you when it's all done. I didn't think it was going to be inappropriate. I thought it was going to be adversarial.
Okay.
And the fact that he was backing himself up with a witness told me, at least it made my, the flag, the spider senses, whatever you want to call it, the defense instinct, that I needed to be recording this conversation because he's got a witness in here. I need to have my recorder running. I had no idea that the conversation was going to go the direction that it went.
And Mr. Wood attempting to influence Summer Shiflett to testify a certain way. Would you agree with that?
Again, I don't know what his intents were, but I can't see any other reason to tell her the things that he did other than to steer her in that direction.
And when you say steer, you mean influence, do you not?
Correct. It's another word for that. Yes.
Okay.
On cross, an attorney for prosecutor Rob Wood pointed out that Shiflett and her attorney never objected during the meeting.
I was doing what my client wanted to do, which was to participate in this interview. And you got to understand, I wasn't running it. She was running it. I was there as legal counsel. And she wanted to do this interview. She wanted to give testimony. She'd been asked to give testimony in that sense. And so she was going to do that. I didn't want to shut this down, but that doesn't take away the concerns that I had at the time. There also wasn't a forum to go to. If I've got a problem with the question you're asking, I could object to it in a setting, not in this setting. It's not my position here. but there's a judge to go to, or hey, let's table this right now and straighten this out in a deposition or something like that. But it wasn't that type of setting. This was unique. Like I said, I've done this type of setting many, many times, but to have this kind of conversation was a little bit, oh, we're doing this. Okay. And I didn't know where it was going to go. I knew I was recording it and I could deal with it later.
Joining us is attorney Dina and Terri Austin. Dina, no one more than a Brooklyn public defender wishes they can throw out a prosecutor for coercing a witness, but I don't know if the law is on their side. What did you think of their arguments and what you saw so far?
I think their argument is actually pretty persuasive. It is sacrosanct that we cannot tamper with witnesses, especially a prosecutor, because the whole point of a witness is to give evidence in a case. And if you start to tamper or influence that evidence is meaningless. And so these rules around how an attorney and especially a prosecutor is supposed to be conducting themselves with a witness. So I think this is actually a pretty strong argument on the defense side.
Yeah, Terri, you kind of agreed. We talked about this before. The defense brought an expert with an interesting view speaking about witnesses and the science behind it. Make some sense of this. How do you think this will affect the outcome of the hearing?
Look, I think Dina makes a very good point. And the forensic psychologist that the defense called, he was excellent. But I actually don't think that his testimony is going to change the outcome. And here's why. I think the motion is going to be denied. And I think prosecutorial misconduct is a very high standard, and I don't think it happened here. I don't think that there was coercion in the sense that we would think of it. And this type of behavior, I think, might have been a bit too far, maybe too personal, but I don't think it was misconduct.
Yeah, there's coercion as we understand it, and there's also coercion as a law, and the courts see it. We'll see if those two fit. Still ahead on Law and Crime Daily, sentencing in the Pajama Pants strangulation case out of Iowa. Plus, the district attorney's decision over whether to charge officers accused of shooting a man in the back, the video and shocking announcement next. Following a months-long review, the district attorney in Kenosha, Wisconsin announces the officers involved in the shooting of Jacob Blake will not be charged, and neither will Blake. Law and Crime's Angenette Levy breaks down what the DA says led him to that decision.
Well, Brian, you may recall Jacob Blake was shot 7 times last summer in that confrontation with Kenosha police. DA Michael Gravely says he's not going to file charges because he believes the officer who fired those shots would successfully be able to argue self-defense at trial.
This was a tragedy first and foremost for Jacob Blake, who still suffers from grievous injuries.
DA Michael Gravely spent nearly 2 hours explaining his decision.
If you do not have a case you can prove beyond a reasonable doubt, as you're going to hear me talk about, then you're ethically obligated not to charge such a case.
The chain of events that led to Jacob Blake started last August when his ex-girlfriend called 911 for help, saying Blake was going to crash her car and had done it before.
On top of that, he's not supposed to be here. Today is his son's birthday, so I allowed him to spend a couple hours with him, but he's not giving me the keys to this rental, and that's all I'm asking for.
There was a felony warrant out for Blake's arrest for domestic violence and sexual assault. Those charges were for an incident involving Blake's ex.
When they come across Jacob Blake, they must attempt to arrest him.
Gravely says it's not seen on the video, but even Blake admitted he resisted arrest, and officers made 3 attempts to bring him under control with a taser. Gravely says Blake even admitted he was armed with a knife, and then tries to go to his car, struggling with officers. Blake's children were inside that vehicle. Officer Rustin Shefsky fired 7 times, those actions deemed reasonable by a use of force expert. Jacob Blake remains paralyzed. He pleaded guilty to 2 charges in December, and prosecutors dropped a 3rd-degree sexual assault charge against him. His family disappointed by the decision, to say the least.
This is a slap in the face by Wisconsin government and the DA and etc. What has happened has perpetuated systemic racism.
We are immensely disappointed with that decision. We believe that there was more than sufficient evidence to find probable cause to charge Officer Shefsky.
Now, this case was not presented to a grand jury. The district attorney said that he consulted with a neutral use of force expert, and that use of force expert is a former police chief. He said that Jacob Blake had both the opportunity and the intent to harm those officers with his knife.
The fact that Blake turned his body in that regard and thrust a knife forward, that was an example of intent. This is probably the question that I have been asked the most. Why 7 shots? Now, first, officers in the state of Wisconsin are trained to shoot until the threat has stopped. That forms the basis.
And that expert, Noble Ray, said that Officer Shesky stopped firing, or said he stopped firing, once Jacob Blake dropped his knife. The DA also said that Officer Shesky provided immediate aid to Jacob Blake following that shooting. Brian?
Thanks, Angenette. Wisconsin district attorneys typically present their evidence to a judge rather than a grand jury, but it appears that a preliminary hearing did not occur in this case. The DA said his decision to decline to file charges relied on evidence that Officer Shesky was confronted with the following: an armed man with a felony warrant, Blake resisting arrest, Blake appearing to be about to flee with a child. The DA says that's when the officer decided to re-engage. Joining me again is Dina and Terri Austin, along with Angenette Levy. Dina, the neutral expert can tell what Blake's intent was, and a felony warrant means self-defense. That's not the law that I practice. Can you make sense of this?
You know, he wasn't neutral to the extent that a jury or judge would be, because the prosecutor here isn't necessarily supposed to be neutral, right? But they are supposed to decide whether or not they can bring this case to trial. And so they didn't necessarily rely on somebody that's neutral. The problem here is that we have seen something like this over and over, and people are going to stop believing in our institutions of justice, which creates a huge problem for us as society. Whether or not in this particular case, yes, they want to be able to arrest somebody who is fleeing with a child and has a felony arrest warrant. But the fact that the police officer yet again came into a situation here where a Black man was shot so many times, it's just one too many times. And I think they should have brought it in front of a judge so people could feel a sense that there was an impartial arbiter here.
Absolutely. Angenette, initial report said Jacob Blake was shot in the back about 7 times, but the DA said that's not the case. What did you learn?
Yeah, the DA said during that press conference, Brian, that he asked the Milwaukee County medical examiner to kind of look at those wounds and make a determination. The best they can tell, they say that Jacob Blake was shot 4 times in the back and 3 times on his left side, which they believe is consistent with that movement they described of him twisting his body with that knife in his hand.
Thanks, Angenette. Coming up on Law and Crime Daily, 2 detectives fired in the Breonna Taylor case. What led the police chief to make determinations official? Plus, how one defendant managed to escape a courthouse, the shocking video you don't want to miss. Two of the officers involved in the Breonna Taylor case have officially been fired. Detectives Joshua Janes and Miles Cosgroves were terminated from the Louisville Police Department. Chief Yvette Gentry had notified the men last week, and the terminations went into effect on Tuesday. Breonna Taylor was killed in March by police inside her home. Janes authored the no-knock warrant. He's accused of lying about information that suspicious packages were sent to Taylor's home. Cosgrove is accused of firing the bullet that killed Taylor. A third detective, Brett Hankinson, was fired in July. He remains the only one charged in the case, but not for Taylor's death. Defendants should know that just because you plead not guilty to a crime, doesn't mean you can just walk free. Law and Crime founder and host of A&E series Court Cam tells us about one inmate who had another idea.
Let's kick things off in the Benton County Justice Center in Washington State, where a judge has found Gerald Hyde II guilty of methamphetamine possession. With the arraignment now over, he's being taken back to jail. Or is he? The defendant has slipped away from security and re-entered the courtroom. He strips off his prison-issue shirt and uses it to hide his handcuffs. He makes it to the hallway, and after a quick look around, he takes off. Along the way, he ditches the distinctive orange prison-issue shoes and continues barefoot through the courthouse. Quickly makes his way to the lobby until he exits straight through the front doors and out onto the street. All before anyone seemingly even noticed he was missing. But within 2 hours, police catch up with him hiding at a friend's house. He's immediately taken back into custody.
And get this, he later decided to represent himself on the escape charge. The jury took all but 13 minutes to convict him. He was later sentenced to 2 years and 2 months in prison. When we come back, a mother accused of killing her daughter with a pair of pajama pants learns how much time she'll spend in jail. A judge's sentence after the break. An Iowa mother convicted of strangling her daughter with a pair of pajama pants was sentenced to 5 years in prison. Authorities say Kelsie Thomas purposely killed 5-year-old Chloe in 2018. A jury last year acquitted Thomas of child endangerment resulting in death, but was hung on first-degree murder. Prosecutors moved for a second trial, and Thomas chose to be tried by a judge rather than a jury. The judge found Thomas guilty of involuntary manslaughter, ruling that she believed the defendant's actions were, quote, in a fit of anger and frustration, not premeditation, as the state suggested.
The defendant told Chloe, "You're going to take a nap or I'm going to beat your ass," because she wanted to make sure she could rest. Chloe, like any other normal 5-year-old, didn't want to take a nap. So she ran away from that bed. And what did her mother do? She took those pajama pants, she threw them over her, pulled back, and strangled her with those pajama pants. In Chloe's last moments on this earth, she would fight for her life, staring at her own mother. We know that the defendant intended to do this act. She intended to cause injury to Chloe Chandler. There is no other intent when you take pajama pants and use them in the way that she did.
The judge's decision was based in part on this so-called confession from one of Thomas's police interviews.
She jumped in her bed, and as I was coming, I came into the room, and she had jumped out of her bed, and I tried to grab her arm, and she slipped out of my arm, and ran out of her bedroom. I grabbed the pants, and I just went like this, and I pulled her. She was everywhere. She was, I mean, like I said, I tried to grab her arm, which stopped her, and she turned, got my arm out, or got her arm out of my hand. So I grabbed the pants, and I threw them over her, and then when I pulled, I don't know, honestly, if I twisted or, I know she had turned around. And we started to fall backwards. So I picked her up and I laid her on her bed, and I held her down and I told her, I was like, you need to go to sleep.
The defense claimed little Chloe accidentally hanged herself and called their own forensic pathologist to demonstrate how she could have tried to free herself from the pajama pants.
There are a wide variety of situations in which this can basically form a 3/4 inch in diameter transverse mark on the neck. One of them is to have it in this particular situation. This is probably about 5/8 of an inch, which is a little bit less than 3/4. But even having something like this, which is basically stretched out and even maybe, which may or may not have been twisted in any way, could have certainly made some kind of a mark as well. Having the presence of seams as well, where these are items that are a little stiffer and that they project, could also make certain kinds of marks in the neck that would be narrower. So this particular kind of garment is capable of making those kinds of marks on the child's neck, in my opinion.
Terry, unlike me, hindsight is 2020. Do you think the defense regrets doing a bench trial the second time around, or is 5 years some sort of victory for them?
Oh, Brian, this is a huge victory for the defense. There's no question that Kelsie killed her daughter. The only question was whether or not it was intentional or voluntary. And for whatever reason, this judge ruled that the prosecution didn't prove that the death was premeditated or intentional. And I think the fact that Kelsie lied multiple times, to me, shows that it was intentional or at least premeditated. And look, 5 years is nothing. The defense got off with a really good break here. And so I think she'll be out of jail in no time with time served.
All right, so Dina, Terry thinks 5 years is nothing, but I want to ask you the same question. 5 years, too light, too heavy? What do you think about the sentence?
Well, she received a maximum sentence for involuntary manslaughter, which was what she was convicted of. And I think that the judge saw this correctly. She said this was a frustrated, tired mother who did not intend to kill her daughter, but in the moment did and felt remorseful about it. And that just rings true with what we know about this. The mother was trying to take a nap before she went on a late shift for work. And unfortunately, she was really overwhelmed. It is a tragedy that a child died here, but this goes to show how much mothers really need support, especially a working mother with a young child.
All right. Well, thank you, Dina, and thank you, Terry, for joining us. And thank you for joining us here at the Law and Crime Daily. We'll see you next time as we discuss justice in America.